Hi, I'm Scott Kuboff, a dental malpractice attorney with the law firm of Ibold and O'Brien. I help my clients receive fair and just compensation for their injuries. I wanted to follow up on a prior video I did on the statute of limitations and discuss an equally important statute when it comes into dental malpractice claims as well as medical claims, and that is the statute of repose. Just a refresh, the statute of limitations sets a time limit on when you can bring claims that have accrued. Accrued is just a lawyer way of saying when you know of a breach of the standard of care and you know of an injury. So the statute of limitation sets the time limit as it relates to accrued claims. The statute of repose works similarly to prevent claims from ever making its way to court, but it works a little bit different way. It prevents claims from accruing, or in other words, it limits the time that you have to discover an injury or otherwise learn of a claim. Now, before I talk specifically as it relates to the statute of repose in Ohio, I just want to remind you that this brief informational video should not substitute actual legal advice in review of the specific facts of your case and an analysis how these statutes apply to your case. If you need that, you need to speak to a lawyer who can intelligently tell you that. In Ohio, the statute of repose is 4 years. In other words, that's as much time as you have to learn of an injury before your claim is barred. However, if during the 3rd year, but before that 4-year limit runs, you learn of an injury, right? At that point in time, you have 1 year from that day to file a claim. So if you have a question on the statute of repose, the statute of limitations, or a dental negligence claim, by all means, feel free to reach out. You can call me 440-285-3511, or feel free to send me an email, scott@iboldobrien.com.